Doug is a graduate of Pennsylvania State University and played football here and in the National Football League. Graduated with a degree in labor. Significantly, actually spent some time actually doing non-sports labor law using his labor degree, turning pro in something other than sports with his degree, before he spent a lengthy career in the National Football League Players Association as most of the time as the deputy director, intimately involved in all activities and principally responsible for their highly successful licensing program. He left there to spend time as the executive director of the Screen Actors Guild during a very contentious time in that period. And he's now back here on campus this semester teaching a course that a number of you I think are in collective bargaining in the sports context. His presence on campus is primarily due to Paul Clark, the director of the Department of Labor and Industrial Relations, and the College of Liberal Arts. Dean Phil McConaughey from the law school was able to provide some modest amount of additional support. And what we got in return, which was not hard bargaining because we probably could have gotten it anyway, was Professor Allen's willingness to come over here a few times during the semester and we can take advantage of his expertise. Today's talk is going to be about the National Football League collective bargaining agreement that was just signed and some of the various dynamics of labor management negotiation. We're going to start with some general questions. We'll run to 7:15. We're going to try to leave room for substantial opportunity for questions from the floor. I want to keep the topic focused on that topic, notwithstanding the wide area of expertise of our special guest, both so we can fully explore that topic and because he has agreed to come back at least twice more during this semester. Once we're going to have a talk specifically focused on the whole issue of agents and the issues that are raised by agents, both in regard to college athletes and in regard to the role that agents play in negotiating contracts in the professional sports context. The second time he's going to come back on yet another topic is to talk about the role of performance-enhancing drugs, and both, again, how that process is negotiated between management and labor, and also the policy issues involving that important topic. So again, it's wonderful to have him here. Let me start by giving a very brief and oversimplified overview of the dispute from my perspective, and then invite some comments, some targeted comments from Professor Allen. The 2006 collective bargaining agreement, which was the last agreement of several negotiated by longtime Commissioner Paul Tagliabue and longtime NFL Players Association Executive Director Gene Upshaw, set the seeds of discord among owners after a decade plus of labor peace, because it included a significant amount of unshared revenue in a category called designated gross revenue that was used to determine the salary cap. So that starting in 2006, it was always true, but to a significant degree, if one owner was able to generate significant unshared revenue, that raised the salary cap for other owners who either couldn't or chose not to or weren't able to raise similar amounts of revenue. This created this discord. Like the 1990s baseball strike, the only common denominator that owners could easily agree to would be to have some modest revenue sharing among the owners, with any additional costs to rich team owners recouped by significant concessions from the players. So that's the way the owners could settle their differences, was basically make this, we'll all come out okay, and the big losers will be the players. The National Hockey League owners' victory in 2004 during their lockout gave the owners some hope that they could force union concessions. The union responded to this by adopting a strategy of getting rid of themselves as a union and going into court and trying to win an antitrust case against the league. The lawsuit, Brady against National Football League, played out with mixed results. For reasons I talked about in sports law, I'll be happy to talk about afterwards to anybody who's interested. The Eighth Circuit did a pretty bad job of statutory interpretation in holding that the Norris-LaGuardia Act, a federal labor-related law, bars any injunction even when the union no longer exists. However, the reality was that this created a significant risk for players that the continuing lockout could weaken their position. At the same time, the Eighth Circuit's refusal to rule on the owner's claim that their conduct was actually completely exempt from the antitrust laws put owners in the position where they would be liable for potentially billions of dollars in treble damages if the case actually went to trial. This combined effect put pressures on the clubs to settle. All right. One of the things that those of you who have had Professor Allen knows is that his basic paradigm in collective bargaining is that the collective bargaining dynamic is characterized by three significant factors: leadership, leverage, and resources. So how would you apply that paradigm to the 2011 negotiations and the collective bargaining?
Well, first of all, thank you very much for having me. I really appreciate the opportunity. Let me give you some context into where that paradigm came from so it will make more sense. We were the executive director of the NFLPA, Gene Upshaw, and the general counsel, Richard Bertelson, and I, and our player president were visiting with the hockey players in Toronto back in the 90s before they were getting ready to go to negotiations and go through that lockout that happened before the big one. And Gene talked about the importance of player leadership. Richard Bertelson, our general counsel, talked about the importance of leverage, including legal leverage, and I talked about the importance of resources. And when we were done, our president at the time, Trace Armstrong, said, you know, that's a really good way to explain the union and what it does to our players. And light bulb went off in everybody's head, and from that point forward, that was a framework we used to talk to players about the union and what it does, particularly in bargaining. In fact, I used that same framework when I was at the Screen Actors Guild. But to relate it to the negotiations in 2011 in the National Football League, there are a number of elements to leadership. The most important of which is an active, engaged, and informed membership, so that you have player leaders in the locker room who can communicate what the union is trying to do and communicate back to the union what the players think. There are other facets to leadership, including leadership from non-player, non-owner groups like agents. You need agents that know what's going on and are willing to stay informed and on the same page with the Players Association. You need, on both sides of the table, you need creative, expert, outside and inside attorneys. And that certainly was true on both sides of the table in this negotiation. But most of the attention is focused on the chief negotiators for each side in professional sports. And in the case of the NFL this year, it was the Commissioner, Roger Goodell, and the new executive director, DeMaurice Smith. They were both new as the chief negotiators. They both faced challenges that were somewhat different. Roger Goodell had been with the National Football League since he was in college. He's not a lawyer. I think he has his MBA, but he'd been with the National Football League throughout his entire work life. And before he was the commissioner, he was essentially the chief operating officer. But he'd never been the lead negotiator. And he also
had he been actively involved in prior labor negotiations?
Yes, but not to the extent that he was always at the table, and he was part of the team, but he had certain areas he was involved in, and other areas he wasn't involved in at all. DeMaurice Smith is brand new because the former executive director, Gene Upshaw, died unexpectedly and tragically in 2008. And the general counsel, Richard Burleson, I was talking about, was the interim executive director, and then they hired D. Smith, who had a couple of challenges coming in. One was some really angry retired players, organized and into several factions, and the fact that the players didn't trust him as a non-player the way they did Gene Upshaw after 25 years. So where Paul Tagliabue, when he was the commissioner, and Gene Upshaw would spend a lot of time negotiating alone. We would go, and sometimes we'd go to negotiations, and there'd be 3 or 4 people on either side of the table, and then one or the other of, after several hours of negotiations, one or the other of them would get up and leave. And then after a few minutes, the other one would leave, and the rest of us would look around and sigh and wait, and sometimes it would be 2 or 3 hours before they would, sometimes they would come back, and sometimes we'd find out that they'd both gone home. But this was I think, an example of the principle that I've mentioned in my class, at least that I believe. That is, when you have negotiators who have that kind of ability to deliver on promises and the trust of their constituents, the way Tagliabue did among the owners and Gene did among the players, you get more done. The amount of progress you make is inversely proportional to the number of people that are in the room. Professor Whitehead and I have had this conversation. When large unions sometimes start out there bargaining, there'll be dozens, sometimes even more. At the Screen Actors Guild, we would have dozens of people in the room, and we would never have in bargaining, other than some exceptional caucuses, fewer than 10 people at the table, which is one of the reasons it was hard to get anything done. Well, Roger Goodell and DeMaurice Smith couldn't do that. They couldn't get up and leave the negotiations for a lot of reasons, but most importantly, they didn't have the kind of trust and confidence among their constituents to do that. So they did. There was another difference in leadership in this negotiation. They brought principles to the table in ways that hadn't been true for decades in the National Football League. So Roger Goodell always had owners present, and DeMaurice Smith always had executive committee members who were active players present. They were people like Drew Brees and Kevin Marai, the president of the union, Jeff Saturday, and Dominic Foxworth particularly, but also occasionally people like Peyton Manning and others would be at the table. And that was a really significant difference between negotiations this year and what had happened over several decades in the past. In terms of other differences in leadership, one of the things that was true in both on the league side, but particularly on the union side, was the use of social media, which was profoundly different in this negotiation than in any other in the past. DeMaurice Smith did a number of things right, and one of them was he brought in some people, consultants, and spent, frankly, a lot of money to make sure they had a social media strategy. And I think this is one of the first collective bargaining processes that was true of, and I call it the Twitter negotiation because so much of it was on Twitter. And if you were following it, you probably know that from seeing what the union and the league had to say. It was a great way to communicate in short bursts with the press, with the players, with the fans, and there were blogs and all sorts of things organized around that social media communication. So there were some real differences in leadership in the way it conducted itself in these negotiations. In terms of the principles that Roger Goodell brought to the table, they were interesting. There were, first of all, what they called privately the two Jerrys, Jerry Jones and Jerry Richardson. Jones from the Cowboys and Richardson from the Carolina team. And Jerry Richardson is a former player, although his claim to that is about the same as mine. He didn't have a long career. But he made his money in the restaurant business and owns that team. But more importantly, I think, there were also involved Robert Kraft, Clark Hunt, John Mara, and Art Rooney Jr. And they were the sort of critical mass of ownership that was able to get this deal done despite the fact that it takes a supermajority and the minority of the owners controls the process, because it requires, it's like the Senate in the U.S. Congress. You can't get it done with a simple majority. You have to have a supermajority, and so the minority that controls, that keeps the supermajority from happening, controls the process. And that means in the National Football League that often hardliners like Jerry Jones or Jerry Richardson or Mike Brown or Al Davis have a lot of influence over the process. But with Robert Kraft and Clark Hunt and John Mara and Art Rooney Jr. involved, they were able to speak for a large enough group of owners that they could ultimately get this done. And that was important. If they hadn't been in the room in a way that was different this time from past years, that wouldn't have been possible. And the interesting thing about those guys is that three of them are owners who are sons of NFL owners. And so they brought not only the broad view of the ownership, they brought the legacy of people like Lamar Hunt and Wellington Mara and Art Rooney Sr., who had in mind long-term goals, league-think goals, and weren't thinking just about their team. Those people needed to be in the room. And the thing that gave them credibility this time was that they were able to communicate with players across the table. They were able to go back and say they looked at people like Kevin Mawae and Jeff Saturday and Dominic Foxworth in the eye. One other difference in terms of leadership was the influence of mediation on this process. Prior to this negotiation, mediation had been, frankly, a disaster whenever it had happened in the National Football League. It was not a success. And I think that's because there's a sort of fundamental principle in negotiations that says that if there's any distance between you as parties, then the mediator's job is to beat up whoever is the weakest to make them concede to the strongest. Mediators don't generally care what the deal looks like, they just want the deal done. And so in my history of the National Football League Players Association, we weren't very excited about mediation. This time I think it helped because it gave this dynamic that Roger Goodell and Morris Smith needed to work out the chance to happen. It gave somebody else's shoulders for all the baggage to be on, and those guys had some room to maneuver. And they kept them at the table in order for these owners I mentioned and these players I mentioned to get to know each other and to be able to work something out. Leverage is an interesting concept in this negotiation, and it happened as a progression. One of the first things that impacted it was the Supreme Court's decision in the American Needle case. American Needle was a hat company that had a long-time license to make hats with NFL team logos with the NFL. They had a license with the league, but they lost it when the league signed an exclusive deal to make the hats to sell to the public with the team logos on them exclusively with Reebok. Now the interesting thing about that is, American Eagle sued them and said that these independent economic competitors like the Cowboys and the Packers couldn't combine their intellectual property rights and preclude somebody like American Eagle from getting a license because they're not a single entity, and that is illegal under the antitrust laws. Well, the interesting thing about that is that the NFL Players Association's marketing company, and its former executive vice president is right up there in the corner, she's my wife. The marketing company had an exclusive with Reebok, and nobody ever brought that up in the course of the litigation, and they didn't get sued. But and I was always waiting for the other shoe to drop and to see whether that would be tested, because while there are exclusions for unions in terms of what they do under antitrust laws, nobody really knows whether their marketing companies will be excluded as well. So the league won the American Eagle case at the district court level and the appeals court level, but they pushed the case to the Supreme Court because they wanted a Supreme Court decision that said, we're a single entity. And they pushed too hard because they went off the cliff, and the Supreme Court voted unanimously that in fact they weren't and aren't a single entity. And that was a real relief to the Players Association, because I talked to DeMaurice Smith when he got hired, and the one thing he was really concerned about was whether or not the league was going to win that case all the way up to the Supreme Court, and that there was going to be a Supreme Court decision that they were in fact a single entity. Because then it's really hard for anybody to sue them under the antitrust laws. And at best, it would be an argument that the union and the players' situation was different. Their market was different than the market for team names and logos. Well, then the NFLPA won an arbitration that was ultimately decided by Judge David Doty, but not sitting as a federal judge, but as the ultimate arbitrator under their collectively bargained system. He decided that the TV contract that the NFL had negotiated recently violated the collective bargaining agreement. Now, how is that possible? Because the owners had agreed in that agreement in 2006 to maximize revenues to the benefit of both the owners and the players. And in the contract they negotiated after that agreement was finalized, they got the TV networks to agree to pay them during the lockout. We might have a lockout. If we do, you have to pay us. Now, it'll be in the form of a loan, and ultimately we'll have to pay you back, but we'll have cash flow. And you pay us the rights fees as if the games were being played. Well, the problem with that is that you can't get that kind of concession without giving up something. And the something you gave up obviously hurt the players because it didn't maximize revenues. You had to make a concession to get that benefit for the owners that didn't benefit the players. So they went through the first step of the arbitration and actually won. And then the union appealed it to Judge Doty, and he said, no, you can't do that. That's not going to benefit. That doesn't benefit the players. It violates the agreement, and I'm not going to let you do it. And there are going to be damages awarded. That was pending during the course of these negotiations. So we've got the American Needle decision, which helps the players and hurts the owners. The Doty decision, which helps the players and hurts the owners. And then a U.S. District Court judge enjoined the lockout. Susan Nelson said that because the union had decertified and was not the collective bargaining agent, they had renounced their bargaining rights, that the owners couldn't get together and decide not to employ the players. To use an analogy that Professor Ross has used, that's like all the law firms in Philadelphia getting together and saying, unless all of the new lawyers agree to the following, we're not hiring any of them. They can't work here. You can't do that. That's illegal. Well, the NFL appealed that decision, that preliminary injunction by Judge Susan Nelson to the 8th Circuit. They stayed it temporarily while they made a judgment, and then they finally decided, so it was never in effect, and they vacated it with their decision saying that, well, whatever else this is, it is under the Norris-LaGuardia Act a labor dispute. So, and that's one of the principles of the Norris-LaGuardia Act, that they said, in a labor dispute you can't issue an injunction. Now, the original purpose of that was so that courts couldn't apply the Sherman Antitrust Act to unions who were on strike. Because when you think about it, a union that collects the workers together and says we're going to withhold our services is a combination, literally a combination in restraint of trade. So if it's not protected from the Sherman Antitrust Act, unions are always going to lose those fights, and it did from 1890 until 1914 when the Clayton Act said, no, you can't do that. Unions are exempt. Well, so we have the NFL getting that injunction vacated, and at the same time that was happening, they filed unfair labor practice charges against the union because they were trying to wrap the National Labor Relations Board around the union like a ball and chain, so that when the players went to the court to get antitrust relief, they'd be able to say, well, if the NLRB decides that the union was guilty of failure to bargain in good faith, then, and particularly if they order them to bargain in good faith, they've got to reset the clock and go back to when they were a union. They don't get to act like this decertification is valid. That was their strategy. So there was a lot of litigation and administrative legal action that was affecting leverage. Now, obviously, the leverage was also impacted by the lockout itself, because players weren't allowed to go to work and weren't getting paid off-season money or bonuses related to off-season activity. And also affecting leverage was the decertification of the union, in which they renounced bargaining and gave up their status as a union. So that was all going on. There was other leverage being exercised by the union's marketing company, NFL Players, because it said to all of the sponsors, the competitors of the sponsors of the league, come make a deal with us. All our agreements not to deal with competitors are over because the agreement's over, the CBA's over. So we'll be, if the league has a deal with Pepsi, we'll make a deal with Coke, and that put pressure obviously on the league. So we've been through leadership and leverage, and now we come to resources. I mentioned to my class that this reminded me of a famous song by Warren Zevon on lawyers, guns, and money, but nobody in the class was old enough to remember that. Some of you professors might. Anyway, in the NFL negotiations, at least 2/3 of that song title were accurate, because resources in this context certainly require lawyers and money. And both sides have a lot of each. With respect to money, the NFL obviously is a $9.5 billion a year business, has some cash flow and some assets, but they also negotiated a line of credit, which was in the billions and substantial. They thought they might get the TV rights fees paid. I think they were whistling past the graveyard, and I don't think they would have gotten that, but they were. That was certainly part of their calculation of their relative resources going into this. The wealth of the owners is obvious. Some of them are billionaires, and they're all fairly wealthy. And so is the quality of their lawyers. People like Bob Batterman, who was the architect of the NHL lockout that forced the players out for a year and essentially broke the collective bargaining agreements back. The owners had the advantage of season ticket deposits made before the season, earning money for them. So they had a lot going for them in terms of resources. On the player side, I would suspect that most of you would look at this and say, well, the owners have a lot more in terms of resources and advantages than the players. It's much closer than you would think, in part because of the licensing activity of Players Inc., the company is now called NFL Players, over the last 20 years. The union has $300 million in assets, including ownership of its building, and also arranged for a $200 million loan. They've been preaching to the players for a long time to save them, and they have their own cadre of very well-qualified, experienced lawyers. People like Jim Quinn from Wild Gotcha and Manges, and Jeff Kessler from Dewey LaBeouf, and of course Richard Burleson, who's been the general counsel there for 40 years. Dee Smith, the new executive director, who's an attorney, brought in his old law firm, Patton Boggs, as well as Latham Watkins, as new members of this all-star team of legal representation. So that sort of gives you a picture of, in terms of a way to evaluate where things are and where they're likely to go, their relative strengths and weaknesses in terms of leadership, leverage, and resources. I think at the end of the day, if you ask the question, who was best able to, the old Batman question, who's best able to walk away from the table and not make the deal, who has the leverage? It's hard to make that judgment. There's advantages on both sides and disadvantages, but it's an endlessly fascinating examination, and I don't think the end results are known yet because the deal's so new.
The NFL contract is for 10 years, but every other major league is currently negotiating. We currently have a situation, and it's only one court of appeals, it's not the Supreme Court, so there's further uncertainty. But if we accept, just for the sake, for the moment, the at least presumptive validity of the Brady holding, we have the legal leverage now being that courts will not enjoin a lockout. So if the NBA or the NHL decides to lock out, the court won't enjoin it. But the courts will not protect a league against treble damages in antitrust if the union chooses to go the decertification route. How does that status quo, in your opinion, affect the leverage calculations in, let's use basketball?
Well, I think you've got to look at the only case the Supreme Court has decided that gives you some guidance on this, and that's a silly little case about the practice squad and whether negotiating a $1,000 a week limit on practice squad players in the NFL was legal. Ultimately, that case was won at the district court and appeals court level by the union and the players, and then lost at the Supreme Court level. And the Supreme Court said this practice squad deal, even though it was implemented after impasse by the owners, was part of the collective bargaining process, so we're going to bless it with the non-statutory labor exemption. You can't sue the owners for that. On the other hand, they said, we're not saying that that is an indefinite extension of the exemption. And the court said that it is entirely possible that you could get far enough away from the collective bargaining process in time and circumstances that the owners would be vulnerable to challenge under the antitrust laws and would be subject to those treble damages. And I think that gives both sides something to worry about. On the player side, the question is if the lockout in basketball continues and the union decertifies and there can't be an injunction to stop the lockout, how long will the players last? I'm not sure that in that sense it makes much difference whether there's, where the litigation stands. The players in a lockout are going to have to resist going back in or signing what the owners are asking for, or have to give up. But the owners have something to worry about too, because that decision in that practice squad case, Brown versus the NFL, is not a particularly helpful guideline. It doesn't tell management, here's what you can do to avoid getting sued. Instead, it says, look, at some point you're going to be guilty, but we're not going to tell you exactly where that is. So it raises uncertainty for the players, because they don't know how long the players' solidarity is going to last, but they can hold out, and for the owners, because they don't know at what point this litigation may turn into something that costs them billions of dollars. And the NBA is in a less robust position to stand that kind of damage claim than the NFL even is. They're claiming, they are in fact claiming poverty and have opened their books up to the players. So, I think in the middle of all that in the NBA, one of the interesting things is the union has been much more reluctant, even before this decision of the 8th Circuit and Brady on the injunction. The union in the NBA has been much more reluctant to pull the decertification trigger. The last time they were going through this and were locked out, in fact, we went up to talk to them and try to convince them that that's what they should do, and they didn't. In large part because their executive director, Billy Hunter, has resisted that tactic. I think he's sort of looking at the baseball players model versus the NFL players model and saying, we need to try solidarity and give it a real hard try before we rely on the antitrust courts. I think it remains to be seen. Right now it seems like, every time you see something coming out of the press, maybe they're making progress, no they're not. Maybe they're making progress, no they're not. The other thing to remember about the NBA is the owners aren't nearly as bad off as they say they are. If you look at their finances, there's this whole argument about whether their depreciation on player salaries is loss when it's not cash, so their finances aren't nearly as bad as they present to the public. But They're not nearly as robust as the NFL because they don't have the TV contract and the shared revenues that the NFL does. So it is different from the NFL, but still in that position where there's uncertainty on both sides, which is often the recipe for a deal, and that's why it happened the way it did in the NFL.
I just, as an aside, as a sort of interesting aspect of law, even for non-law students here, usually, and a lot of time we spend in law school, is trying to figure out how to make law clear, transparent, and certain. You know, the idea that the law is substantively uncertain, and then if you go to court, you know, it depends on what the judge had for breakfast. This is something that usually people don't like. We would say that if securities laws was uncertain, corporations wouldn't feel comfortable raising capital. Or because medical malpractice is uncertain, doctors don't exactly know what to do. They practice a lot of defensive medicine or something like that. But if your goal is to get the parties to an agreement, and what most people want in sports is everybody's got an opinion about the salary cap or some free agency or something like that, but there is no fan who wouldn't trade the worst deal on the table and a season for the best deal on the season only after a year's lockout. So everybody wants a season. And what's interesting is that the uncertainty in the legal sense, as well as in the economic sense, creates the leverage dynamic to actually get a settlement. And having the law be absolutely crystal clear would actually in some ways create a detriment.
Well, and I think a great example of that is what happened in baseball. Because in baseball, folks in my class know this, in the 20s, the Supreme Court said baseball was exempt from antitrust challenge, no matter what, because it wasn't interstate commerce. And even when they admitted later it was interstate commerce, they said, well, it's been 50, 70 years since we made that decision. Baseball's relied on it. We're not going to change it for baseball. Well, that meant the players didn't have this decertification, sue the owners under the antitrust laws option that all the other sports had. And the only thing they had was solidarity. Now, they had a really smart executive director that came out of the Steelworkers Union, and he built a culture of solidarity over time that became a tradition in their membership and in their union. And they sort of bond by going through the experience of the minor leagues together. But they struck successfully and resisted lockout successfully because that's all they had. They didn't have anything else. They didn't do that. They were going to be ground into the dust. But it also meant there was a lot of turmoil. There was a lot of disruption. The playoffs were canceled, and it was tough on the owners, tough on the players, and tough on the fans. And then they got the Congress. We don't need to go through all the whys and wherefores, but they got the Congress to agree that they would have the same protections that anybody else does under the antitrust law. They would be just like the football players, the basketball players, the hockey players. They would be covered by the antitrust law. Otherwise, baseball would be exempt, but not for the purpose of players. And then after that, there was a long extended period of labor peace. And I think that has something to do with it because they didn't have any uncertainty. They knew if they weren't solid and they weren't able to strike and they weren't able to resist the lockout, they were going to get buried, as opposed to the circumstances they're in now.
I have one more question that I prepared, and then I'd like to throw it up to the floor. Actually, I have a bunch of questions prepared, but I'll ask one more before I cede the floor. I have, in a lot of my work, which focuses on some of the challenges that leagues face because they're run by owners who are not engaged in what the famous book once referred to as league think, but they're really just self-interested in their own club. And there's challenges in a number of areas, labor just being one of them. And so what I've previously opined is, if you told Roger Goodell you got a 20-year contract and nobody can fire you, and you have sole authority, you got the deal done. So you don't have to worry about getting fired. All you have to do is what you think is in the best interest of the league.
That was essentially what Gene Upshaw had on the other side.
Yeah. If you had that, D. Smith and Roger Goodell could have gotten a deal done way earlier. Do you agree with that, or do you think are there more nuanced dynamics that make this overly simple?
I think it is absolutely true that it is more difficult to get a deal with the National Football League because of their supermajority, and what it often means is the hardest line owner is in charge of labor relations. And the worst example of that in the National Football League was the now deceased owner of the Tampa Bay Buccaneers, Hugh Culverhouse. Hugh Culverhouse hated unions. In my personal opinion, I won't be pejorative. He was not a nice man, and he was not interested in collective bargaining, and basically did everything he could to bust the union. And he was in charge of labor relations and the chairman of the management council that did the bargaining because of he had enough allies, and it didn't take very many, to control the minority that would prevent the supermajority from agreeing to anything. So it only took 4 owners out of the 6 on the management council to control the whole process, and he had 3 other allies. That's not a healthy circumstance, particularly for players and their union, but it doesn't bode well for bargaining, and bargaining in those years was unproductive and contentious and toxic, and I think that is an example of what you're talking about.
Questions from the floor? Well, let me ask my next question while you get over your shyness. What portions of the new collective bargaining agreement are particularly favorable to players? And what portions would you say of the new NFL deal are particularly favorable to owners?
I think it's a pretty good deal for both, with some exceptions. I don't think that I have a really hard time swallowing a 10-year deal. I think that's a long period of time in labor relations, and there's no relief valve. There was a lot of talk about it being a 7-year deal with.
Who benefits from the 10-year deal?
I think it depends on how it works out, and the problem is whoever decides after 4 or 5 years that it's not working for them, the way the owners did in the last deal, there's nowhere to go. There's nowhere to release the pressure, and if the relationship becomes toxic, as any of you have dealt with collective bargaining know, they're living agreements. You don't solve all of your problems in one document, and to the extent that problems pile up and the arbitration procedure isn't fast enough or productive enough to get the problem solved, then the parties keep pulling farther and farther apart, and it becomes really hard to solve problems that were unanticipated. So I'm worried about that, although frankly, privately, some of the folks involved will tell you that they're, on the union side at least, they believe that after 3 years, they would be free to decertify, to get out from under a bad agreement. So they do have that. That's really a nuclear option to force an end to the agreement that way, but that is one option. I think it would have been better if it were shorter for both of them, but probably better for the players if it were shorter than for the owners. The players got a lot out of this that's good, in addition to lifting the floor on the cap so that the teams are guaranteed to spend more at a minimum. They got that. They also put a lot of money into the retired players' pockets, particularly the players that played before '93. They funded that from both sides of the salary cap, but the owners are putting in actual money, and it's a total of $600 million over the 10 years. It's going to improve pensions for older players by at least $1,000 a month. That's their goal. The players also.
So you're making out that
I didn't play long enough to bet. No. But one of the things the players are particularly happy about is the change in the work rules. You know, when in collective bargaining, we always teach that mandatory subjects include wages, hours, and working conditions. Well, working conditions in the National Football League are really important because they're 250-pound guys flying at each other, so they want to know how often they have to do that. Well, they severely restricted how often. And where it used to be 14 weeks of off-season practices, it's now 9, and only 3 of them are practices team against team with the coaches, and very few in pad. They eliminated 2-a-days in preseason, and they don't. That isn't going to change the sport at all. Players maintain peak conditioning now year-round. When I played, guys would go get second jobs and disappear for 6 months, and the long preseason was to get them back into shape because they weren't working out. They were smoking and selling real estate in the off-season because nobody made any money in those days. Well, now that's not true. Now that every second of your year is devoted to staying in peak condition, and they're like Olympic athletes. They worry about being able to cycle in and out of condition. So they got a great package of restrictions on practice that will help them be injured less often and extend their careers. One thing I said that was obvious in terms of leadership was there were no coaches in this negotiation. They're not, when it comes to collective bargaining, the owners and the league folks push the coaches out of the room, and that they're certainly not in there with the players. And because coaches want to coach, that's what they do. They want to coach 24 hours a day, 7 days a week. In this deal, their viewpoint was buried, and they're not going to get to do that anymore, which is going to be healthier for the game and better for the players. The owners got a reduction in the amount of money that the players get under the salary cap. Now, they were asking for an 18% reduction. They didn't get that. They got about 3.5%. And the players weren't happy about that. On the other hand, yeah, on a $9.5 billion revenue base, it is. On the other hand, it was a lot less than they said they needed going in. And there's also the way that it works is they lifted the floor up, so the distance between the minimum they had to spend and the maximum they spend is now compressed, and they have to. So some of these teams that were getting away with spending less are going to have to spend much closer to the cap, and overall that'll mean more money for players. They got some significant increases in the minimum salaries. Now the minimum for a rookie is $375 this year, but it goes up to $400 pretty soon. So the spread, as this agreement goes along, is going to be roughly $500 to $1 million. And at the top end of that, the older players minimum doesn't all count against the cap. So there's not going to be an incentive to get rid of an older minimum salary player to get a younger one. As you get older, less of your minimum counts against the cap. So there are all kinds of things like that that are good for players. They improved the benefit for players who suffer from dementia and from concussion after effects, and they also made some modest improvements in the post-career health insurance, that sort of thing. So there was a lot in there for the players.
Mr. Brown.
Hi.
Could you push your button so people can carve out?
Where's my button? This?
Yeah.
Oh, okay. Now it turned green. Okay. Look, one of the things that was